Thing ready. Good morning to everybody. And I'm sure that I could see you on the screen. And today is of course, this is a good afternoon is the right word because generally I'm used to take the classes in the morning. That's the only that we habituated to say the good morning only, but it is a good afternoon. Happy Guru Purnima because everybody has today sent that happy Guru Purnima. So I reciprocally I do the same thing. Yes, I could saw the chat. Good afternoon over here. Yes, come to the point because as you know that and if you see it. Then I will make another slide here after that one. This is regarding the good afternoon slide. This is yeah. This slide shows yes. This is good afternoon. After it, before the people will join over there, I'm sure that you are hearing me, isn't it? Yeah, yeah, yes, yes. Please welcome. If you hear me, then you can see. You can tell me. You can speak with me that sir, I'm hearing your voice as well as I could see the screen, and the screen is written. What is the on the screen? It is written over there. Please tell me for my confirmation, so that I could know that you are with me and we are traveling the same boat. Yes,
Good,
Good afternoon.
good
yes.
afternoon, sir.
Very nice, very nice. What is the background of the color?
Blue.
Yes, yes, yes. I would like to see whether the color is seen in a proper way or not. That's my intention. But anyway, that shall we wait and shall we start it because the time is now, as per the schedule, is yeah, it's 3:01. 1 minute is there, but still people are joining over there. So let me give the chance to them for 1 or 2 minutes. Then I will start my class. Before that, you could ask any questions that you would like to ask. Yes, any other question that you would like to ask? Yes, let me speak to you that regarding the today class is concerned, and what about the today class? Actually, we have it. See, we covered the many things. The last point which you could see on the screen, and I'm sure that you could see the screen. Is it not? Yeah, that is IPR and others laws. That is the 16 questions. That is the 16 marks are there, and there are around about 7 to 8 acts are there, like Copyright Act, Patent Act, Environmental Protection Act, Human Rights, the Protection of Human Rights Act, Silent Features of the Information Technology Act. Then the last one is the Right to Information Act. These are all the acts are there, but in each act there are maybe naturally the 2 or 3 questions may be asked because there are the eight acts are there, so in each act, there would be the 2 questions which is going to be asked over there. Sir, can we work for the 2 questions, sir? We have to read the entire act. Yes, you have to read the entire act or sometimes selected one. And it is your fate because I told you that no one could score in the entrance 100 by 100. Did you see any time any person scored 100 by 100? Yes. Answer. Answer.
No, sir.
Did any person scored 100 by 100 in the entrance?
No, no, sir.
Till still my knowledge goes, even the paper setter, I repeat, even the paper setter who sent the paper, I'm sure when he asked after the 10 or 15 days later, and if you ask him, at least he will lose 1 mark unless unless he readily touch with that subject, daily see it, then he could keep in a memory, and that unless he is a photographic memory. That's I want to share. So today class that I would like to make the Copyright Act 1957, Patent Act 1970, then silent features of the Information Technology Act, then the last one is Right to Information Act 2005, and the Right to Information Act 2005 you already studied it. I'm sure that you will do the questions very well in when I come to this Right to Information Act when I was discussing this thing and bring on the screen. Yes, now the time is it is 3:04. That means it's still 1 minute would be there for the latecomers, so that they could not lose it. What do you say? Yes, say something. Shall I start it?
Yes, sir.
Very good, very good. Such an answer I should have to get it so that I could continue my class. Yes, come to the point. And Suppose
Good
if
evening.
any, yes, good evening to everybody. You are welcome to the class, and the class is in progress now. And what do you like to hear the first one? Which one the act? Because I'm ready with all the things, especially Copyright Act, Patent Act, and Information Technology Act and Right to Information Act. Which one that you want to start? Sir, why do you ask such a question? Start anything which you want to start it. But I would like to give the liberty to the my students.
Patent Act, sir.
Pardon?
Patent Act, sir.
Patent Act, yes. When you say the Patent Act, okay, I will turn to the Patent Act. Now I will start it. Yes, this is the MCQ in the Patent Act 1970. Then naturally, that the first question generally we asked over there, and I'm sure that you could see my screen, isn't it? See, I enlarged it also. Now you could see my screen in well way, in better manner. Yes, whenever the questions would be there, any act would be there. First, they will ask when it is enacted and when it is coming to effect. That is, mean the enforcement day. Then generally this thing will be asked over there. And moreover, they will also ask that how many chapters are there, how many parts are there, how many sections are there. Because generally, this is the question which is they are going to ask to know whether this person really seen the bare act or not. To ascertain it. If you have seen it, at least you could remember some of the things or not. Because that's why they have given the A, B, C, D out of it. If you have really seen it and if you have really gone through that act, I'm sure that in the photographic mind that you will capture it and they review it definitely and you will mark the right answer. Yes. Coming to the point, I am sure that you read it. Anybody can read on that which is there on the screen? Hurry up.
Yes, sir. How many
Yes.
chapters and how many sections are in the Patent Act 1970?
Yes,
The
answer.
question.
Answer.
Answer. All are 23 and 163.
Yes, it is the answer is 23 and 160 is the right answer over there. Because if a person who has really seen the act, definitely without having a second thought, he will go and tick that mark. Yes, here WIPO, I am sure that everybody knows it.
World Intellectual Property Organization.
Yes, before I could ask or think that you are in a position to give the answer, before I finish my last word of the question. Yes, it is the World Intellectual Property Organization is the correct word because I wrote the different terminologies over there. But really, if a person who has seen the WIPO, definitely he will, without having a second thought, and he will take it World Intellectual Property Organization. Then the third question is, read anyone.
Patent Act was enacted.
The Patent Act was enacted by the Government of India the year 1970 in pursuance of its powers under entry of
Dash.
the list of the list first of schedule 7th of the Constitution of India.
Yes, which schedule it is there? Of course, schedule already given, 7 schedule of the Constitution of India. And entry, is it a concurrent list? Is it a state list? Is it a central list?
List.
I already made it. It is very much clear. List 1. What is list 1?
Central list.
It is a list 1 is there. Yes. What is the entry? Entry number? Sir, we know the list, but I did not expect that entry. Yes, the question may be asked in that way.
49. 49.
Yes, right answer is 49. Yeah, next, anyone? Not the same person should
Patents
not
Act
read.
was largely based on the Patents Act was largely based on the recommendations of the committee report headed by
Yes.
Swaminathan Committee, Justice Swaminathan
Yes,
Committee.
it's a Rajagopal Iyengar, not Swami Iyengar. It is Justice N. Rajagopal Iyengar is the right answer. And based on his recommendations, this is made over there. Because this is created by me. That's why you could not see in the objective type on the website also. Yes. And next is, yes, anyone can read.
An application for termination of a computer license can be
Not
filed under
computer, compulsory.
compulsory license can be filed under provisions
Yes.
of
Unless you go through it, we could not know it which provision says over there because certain questions are very difficult. But the
94.
it is
Section 94.
Section 93 is the right answer for that one. The license are concerned. Yes, next come is please read the another person. Give the option to the person, those who are participants. Because I would like to see that how do you read it. Anyone? Anyone in the sense the person those who read you could not get the chance. Give a new person. Yes, new person. Sir, we did not have such a device to read it. Yes, anyone?
1970 along with the
The
Patents Rights 1972
came into
prime
force
into force
on 20th April.
20th April 1972,
Replay.
replacing the
Which is the right answer? Which is the right answer?
I think it is B.
E, sir. Indian Patents and Designs Act 1911.
Indian Patents and Designs Code of 1911 is the right answer? No. Indian Patent and Design Act 1911 is the right answer. B is the right answer for that one because the Patents Act 1970 along with the patent rules of 1972 came into force to 20th April 1972 replacing the Indian Patent and Design Act 1911 because that is the old act would be there that is repealed. Yes, the Patent Act 1977 a patent may be revoked under section.
22, sir.
Yes,
Patent Act 1977, 72, sir. Section 72.
answer is 72. The Patent Act of 1977, a patent may be revoked under section 72. That is the Patent Act clearly says over there. Then the next question, Patent Amendment Act 2005 on 4th April 2005, which was brought into force from. This is a bit difficult task because generally they may ask such a question also. That's why I framed it. When it is.
It is 1/1/2005.
It is 1/1/2005 is the right answer for that one. Unless until that you read it and you can make a photographic man, then only you could remember it, or you develop your own method to see that how it could be remembered. Yes, next question is ninth one. Insertion of the new chapter 4A. After the chapter 4 of the Principal Act, the following chapter shall be inserted, namely chapter 4A, exclusive marketing rights, under which amendment chapter 4A is inserted. Of course, now it is repealed also.
2005.
The right answer is the Patent Amendment Act of 1999. They inserted the 4A. Suppose if you happen to see the Patent Act, and I saw the Patent Act, it is repealed also. Even made, and I will show you the Patent Act where it is. Yes, now I will show you where it is repealed also. Patent Act. Yeah, if you happen to, your patent. I don't know whether I think I did not save it. That's the reason I could not find it over there.
Is it because of the existence of WTO, sir?
Because I don't know what is the reason is there. Because first they inserted it, but when I checked it, no, they said repealed. 4A is repealed. But when it is repealed, please you can check also because I say only inserted. But the question also they may be asked that when it is repealed. So that also can be asked. But when you check the act, you see that it is repealed. Now, anyway, come to the point of which of the following is not an intellectual property.
Customs Act. Customs Act.
It is very, without having the second thought, you can say that Customs Act will not come under the act of the patent law. A new way to process milk so that there is no fat in any cheese made from it. So which will cover over there?
That is, I think, trademark.
Is it trademark? It is a process. It is a process, I say.
Patent.
When there is a invention, please note the point. When there is a invention, it is a patent. When it is a reproducing, it is a copyright. When that logo is not to be used by any other person,
Then it is copyright.
Is a trademark. And when is a design would be there, then you can industrial design. So these are the different are, but all are come under
That intellectual property.
intellectual property. So intellectual property is specie or genus?
That is genus.
That is a genus, and all other things are special. Because one of the questions I asked the same thing. Yes, now come to the point of the first legislation in India relating to patent was the Act 6 of
1956.
1856.
Sorry,
It
sir.
is 1856. Based on that one, the Patent Act actually made it. This is 1856 of the British Act, British Patent Act. The based on that thing, yeah, and this Patent Act is made. Yes. Then we'll come to the next question: is first patent litigation in India post India's 2005 product patent regime, which included public interest and pricing issue, decided in the case of. In other words, the first patent case law. I say post India's product patent regime. It is famous for the patent litigation. Which case law it
Then
is?
it should be Novartis versus Union of India.
That is answer is C. That is F. Huffman Law, Rochelle Limited versus Cipla Limited. It is the New Delhi. Actually, it is decided. It's a Bombay Central actually, but somewhere, of course, there is another case law. So it is a Rochelle Limited versus Cipla Company, the first patent law which is decided in the India. Yes, broadly speaking, appeals to the Supreme Court of India in patent matters are filed under the Supreme Court's which power?
Mandatory power.
It is a discretionary power, not a mandatory power. The broadly speaking, appeals to the Supreme Court of India in patent matters are filed under the Supreme Court's discretionary power. It is not a mandatory power, would be there, or not obligatory, or none of the above. It is a discretionary power of the court, would be there. Of course, you might have seen that there are many types of the, what I say, petitions are there in the Supreme Court. Of course, it does not refer to only to these cases like special leave petition and civil appeals, criminal appeals, discretionary appeals, and then curative appeals. So there are different types of the appeals would be there, but here in the patent they say discretionary power they do have it to deal such a cases. Yes, come to the next point is in India inventions are generally
Patent
protected
Act.
by.
Patent Act.
I already made it in my discussion that inventions, when the word will come, then the patent will come. When the reproductions will come, then the copyright will come. Yeah. So we are International Limited versus another Mexican Healthcare Private Limited held that the acts of the defendant for unauthorized manufacturing and selling of the patented product amounts to infringement of the plaintiff's right granted under section dash of the Patent Act 1970. Which act? Infringement of the patents.
I think it's 46 because it comes under Copyrights Act. Copyright, sir.
Answer
Copyrights
is 48. 45, 46, 47, 48. Then the answer is 48 is the right answer for that one. That is infringement of the patents. Next, come to the yes. Read. Anyone can read it. Yes. New person. Please read. Samasara. I saw, but he disappeared again. Okay. Yeah, Patent Amendment Rules 2006. The last amendment are made effective from.
May 2006, sir.
This is rules. I am speaking about the rules. Yes, it is a 2006, but which date? Date.
5th May, sir.
5th May 2006, the correct date for that one. Yes, you are right. So next 18th question. The government of India constituted a committee under the chairmanship of Dash, a retired judge of the Lahore High Court in 1949 to review the patent laws in India in order to ensure that the patent system is conducive to the national interest.
I think Manmohan Lal Sarin.
Answer is Justice Dr. Bakshi Tek Chand. He was the one of the eminent person at that time when in 1949, and he is very much close to even to the Manmohan Lal Sarin and M.M. Munir. M.M. Munir has written a book. I think it is Munir Law of Evidence, if I not be mistaken, that he wrote it. And that is Bakshi Tek Chand is the right person for that one. Under the chairmanship, the patent law in the India is reviewed over there, under his chairmanship. Yes, patent can't protect. Of course, it's a very easy idea. I can.
No opinion. All of the above. All of the above.
All of the above, because all are not in an active movement, idea, thought, opinion. All of the above is the right answer for that one. The term of every patent granted under the Act is dash year from the date of filing. How many days should be there?
20 years.
Answer is 20 years. Yes, answer is 20 years. The right answer. But I want to see if anybody there is in lobby. You are not saying there are 6 persons are there in lobby. Total 6 persons are there in the lobby.
Because they are not informed us, sir.
Because I checked it to see whether how many are there. So I found these are things. Anyway, it's no matter that because yeah, 22 is the answer for them. Not answer, participants. Yeah, 20 is the answer for that one. And this is the end of it because this much is enough for that one. The next, now you can choose the action. What was the next one? Because I told you that what do you want? Because first we did the patent, and next what do you want? Right to Information Act or Information Technology or Copyright Act?
Copyrights.
Copyrights, yes. I will do the copyrights. Now we'll see the copyrights. Okay, no, not thank you. Thank you later on. Copyrights, let's say. Yes, MCQ in Copyright Act 1957. I will make it big so that you could see the screen. Yes, sir. Don't ask what is MCQ, please. Is there anybody who did not know what is MCQ?
Multiple choice questions.
Yes, that is the answer. Yes, answer. Now, how many chapters dash and how many section dash in the Copyright Act 1957?
2479.
2579 is the correct answer. 2579 is the correct answer. That is the chapter 25 and sections 29. That is the answer for that one. Yes, intellectual property is dash and a Copyright Act 1957 is. Now you tell me. Which is the genus? I already told you in the earlier classes in the
Genus species.
This is a genus specie, not specie genus, not specie genus. Spelling I made the wrong here. And the right answer is the first one. That A is the right answer. That is the intellectual property is the genus, and the Copyright Act is the 1957 is the specie. Next, the third question is which of the following would not gain copyright protection? Yes, a DV.
Recorded speech.
Yes, yes. Somebody told it. Correct answer. Unrecorded speech is not a copyright protection. So feedback also I have given over there because films, broadcast, topographical arrangements, published editions, all these things come under the literary, dramatic, musical, artistic works. Everything will come under the Copyright Act. Therefore, unrecorded speech would not gain the protection of it. Then the fourth question is, read anyone?
Duration of copyright protection.
The day.
Okay.
20 years of the day the
It is a permanent one, sir.
See, I will make it. I changed it. Yes, now you tell me. What is the period of the copyright?
Well, will not gain copyright protection. No, sorry.
This is copyright protection. Answer is?
the day the author dies.
70 years from the end of the calendar year in which the author died. 70 years, that is the answer. That is, a novel is a literary work and the duration of the copyright is 70 years from the end of the calendar year in which the author died. That is the right answer for that one. Your fifth one is, yes, tell me, which one of the following action is not a breach of copyright?
To make a copy of CD and sell it.
Copied CD, sir.
To borrow a CD from your friend and copy it to your laptop for your own private use.
Okay,
It's not a breach of Copyright Act because you are using it for your own use. Suppose if you make it a commercial, then it comes. Suppose somebody is wrote the moot court now. So now it is selling. When selling comes, no, it is a copyright. When you are giving free means it is not a copyright. Are you following me? Yes, come to the point is which of the one of the following that is the answer for that one, the sixth fantasy. This act may be called the Copyright Act 1957, extended to the whole of the India except.
Jammu and Kashmir.
I know that you are going to say the same thing. I intentionally asked this question. It is
Now it is defunct.
now
Now it is defunct. But when it started,
no. When it started, also Jammu and Kashmir is included over there. It is applicable to the whole India. Yeah.
Except Union territories.
Yes. Yes. In the beginning, also it is.
Goa is not included. I know that. And Goa is a union territory.
No, the last one is it is applicable to the entire India because I saw in the act itself. In the act itself, I saw it.
It is extended to Goa later, sir. Goa and Dayu Daman, the act is extended to Goa and Dayu Daman later.
No, I will show you. I will show you that Copyright Act. What is Copyright Act? I will show you, so that our doubt will be cleared. Copyright. Yes, Copyright Act, Bare Act. See, if you happen to see the Copyright Act, which I put it over there. See, here it is given. Did you read it now? See, short title it is given over there. It shall come into force on such a day central government may be notification comes there and it extends to the whole of India. It is written over there. Did you see it? Did you see it? It is extended the. It will be called the Copyright Act 1957. It extends to the whole of India. Is it clear? Yes, please tell me. So that is the thing which is made over there. Yes. Now come to the point. According to the Copyright Act 1957, the following is not protected work: literary and musical work, dramatic and artistic work, cinematographer work, audio tape and computer software, and mere variation of the typographical ornamentation and lettering or coloring. These are the four choices are there. Which one is the correct choice? Yes, anyone? I could not hear your voice. That's why I'm worried about it. Yes, anyone can give the answer for that one. Are you hearing me? Answer is the mere variation of typography, ornamentation, lettering or coloring is the right answer for that one because literary and musical works also covers, dramatic and artistic also covers, cinematographic work and audio tape and computer also covers over there. Then the last one is not covered over there under the Copyright Act. Are you with me? Because I could not hear your sound. That's why I'm worried. Yes, please, anyone can chat or send the reply. Are you with